Welcome to another new episode. Like always, today we are here with an exciting topic that will boost your knowledge. So, without further ado, let's jump straight into the main discussion.
Hey everyone, welcome to The Explainer. Today we're diving into what I think is a truly wild legal mystery. We're going to look at how a single, seemingly basic word ended up sparking nearly a century of intense litigation, frantic legislative scrambling, and a massive judicial tug of war. We're talking about one word that literally determined the fate, the livelihoods, and the physical safety of thousands of maritime workers. So what exactly makes someone a seaman? I really want you to think about that for a second. It sounds like a total no-brainer, right? You probably just picture someone on a boat out on the ocean. But here's the thing. In the eyes of the law, the answer to this incredibly basic question determines who gets life-saving legal protections and who gets left entirely out in the cold if they're horribly injured on the job. The definition shifted, morphed, and sparked a debate so huge it went all the way to the Supreme Court multiple times. All right, let's jump straight into Section 1, the perils of the sea. Now, before we get bogged down in complex statutes and courtroom drama, we've got to understand the very real human stakes here. We're talking about the extreme dangers of the 19th century: crushing equipment, violent storms, absolutely unforgiving working conditions. These workers face the literal perils of the sea. Our story really kicks off in 1896 with a man named Patrick Shea. Shea was a crew member aboard a ship called the Osceola, and while they were out at open sea, a heavy derrick fell and struck him, causing a devastating injury. Shea tried to sue the ship's owners, basically arguing that the master of the ship was negligent in ordering the use of that derrick. And man, his lawsuit essentially lit the fuse on a cascade of legal battles that would rage for decades. Well, by 1903, the Supreme Court handed down its ruling in the Osceola case, and it was a massive blow to maritime workers. The court decided that injured sailors were only entitled to something called maintenance and cure. Now, this is an ancient concept dating all the way back to the Middle Ages, which basically just provides basic medical care and wages, but only until the end of the voyage. But here is the absolute kicker. The court explicitly blocked seamen from suing their employers for negligence. They applied land-based legal theories, like the fellow servant defense. That meant if another crew member caused your injury, your employer wasn't liable at all. It left injured sailors incredibly vulnerable. Which brings us to Section 2, the legislative ping pong. When the courts shut a door this heavily on injured workers, it usually prompts a huge reaction. Let's walk through this legislative back and forth as Congress desperately tried to patch this hole. Step 1. Congress passes the Seamen's Act of 1915, intending it as sort of a legislative veto to the Osceola. They declared that a seaman in command is not a fellow servant, trying to soften that harsh land-based defense. But Step 2. The Supreme Court pushes back. In a case called Chalentis, the court points out a massive loophole. Congress totally overlooked the part of the Osceola ruling that barred suits for the negligence of any crew member beyond that basic maintenance and cure. So back to the drawing board they go. Finally, we hit Step 3. Congress enacts the 1920 Jones Act. This was a total game changer. It modeled protections after railway workers and finally gave seamen the explicit right to sue their employers for negligence, including the right to a jury trial. Moving on to Section 3, the missing definition. Okay, this brings us to what has to be one of the most baffling errors in American legislative history. Congress created these powerful, generous legal remedies for a very specific group of people through the Jones Act. But incredibly, they completely forgot to specify who actually belonged in that group. I mean, they literally never defined the word seaman. This massive oversight meant the courts were suddenly burdened with figuring out exactly who got these generous benefits and who didn't. Was a guy repairing a docked boat a seaman? What about a pilot on a seasonal sightseeing ferry? It was entirely up in the air. And the sheer irony of this whole situation, the absolute best statutory definition of a seaman wasn't even in the Jones Act. It was actually written into an entirely different piece of legislation, the Longshore and Harbor Workers Compensation Act, or LHWCA. The LHWCA defined a seaman as a master or member of a crew of any vessel. Now, why is that so ironic? Because the LHWCA was specifically designed to provide compensation to shore-based workers, and it used this exact, precise definition to explicitly exclude seamen from its coverage. So the courts ended up borrowing this exclusion language just to figure out who was a seaman under the Jones Act. You really can't make this stuff up. All right, Section 4, a tale of two circuits. So when the Supreme Court's early guidance left far too much ambiguity, we see exactly what you'd expect. Regional federal courts formed battling factions, basically trying to solve this definitional riddle on their own. Two prominent approaches emerged. On one side, we have the Fifth Circuit, which created the Robison test. This was a really broad definition. It just required that a worker perform a substantial part of their work on a vessel and contribute to its function or mission. But on the other side, the Seventh Circuit created the Johnson test, and this was much, much narrower. They demanded that a worker must contribute significantly to the vessel's transportation function, meaning if you weren't actively helping navigate the ship across the water, the Seventh Circuit said, nope, you're not a seaman. Let's take a closer look at the Fifth Circuit's reasoning here, because it's pretty compelling. They argued, and I quote, workers aboard platforms share the same marine risks. They run the risk of top-heavy drilling barges collapsing. This perfectly encapsulates their philosophy, right? The Fifth Circuit wanted the Jones Act to protect anyone facing the unique, terrifying hazards in working on the water, like offshore oil rig workers, regardless of whether their traditional job title involves steering a ship. To them, exposure to the peril was what truly mattered. Which leads us to our final part, Section 5, muddling the waters. To definitively settle this ongoing dispute, the Supreme Court finally stepped back in. In 1991, they heard the Willander case. Willander was actually injured while inspecting a pipe on a paint boat in the Persian Gulf. And the Supreme Court used this specific case to outright reject the Seventh Circuit's strict aid and navigation requirement. They declared that a worker doesn't have to literally steer the boat, they only need to be doing the ship's work. So this seemingly expanded protections, right? Well, the confusion definitely didn't stop there. Lower courts almost immediately started fighting over what constituted a substantial amount of the ship's work. Just 4 years later, in 1995, the Supreme Court had to intervene yet again, this time with the Latsis decision. This ruling basically forced courts to look at a worker's job like a fragmented pie chart. The court ruled that a worker must have a connection to a vessel that is substantial both in nature and in duration. Now, what does that actually mean in practice? It meant courts now had to meticulously dissect, measure, and divide up a worker's time, their duties, and their locations, literally slicing their employment history into tiny little pieces, just to see if their connection to a ship met this new highly analytical threshold. So let's crystallize exactly where things landed. Here is the final three-part test that emerged after literally a century of legislative and judicial struggle. To be a seaman under the Jones Act today, you must prove, number 1, you are doing the ship's work. Number 2, you have a connection to a vessel in navigation. And number 3, that connection is substantial in both nature and duration. It's a highly fact-specific test that really shifted the boundaries of liability and ultimately restricted the scope of who actually gets covered. And this leaves us with an incredibly provocative thought from the legal scholars reviewing these cases. They argue by leaving some traditional seamen vulnerable to the perils of the sea, the Latsis test is inconsistent with the policy of the Jones Act. It asks a really profound question, doesn't it? Did this century-long legal quest to define a single word actually succeed in protecting the vulnerable workers it was originally meant to save? Or did it just create a convoluted maze of judicial tests that leaves some stranded? It's a complex reality that shows just how powerful and sometimes perilous the law can be. Thanks so much for joining me on this explainer. I'll catch you next.
How did you like today's discussion? If you have any questions about this topic, don't forget to let me know in the comment. Stay well, stay healthy.